Good to see you, Kirsty.
Hello.
So, my goodness, I mean, the charities who are involved in helping those who are victims of sexual assault are outraged. One can only assume the victims are absolutely concerned, at the very least, about this. And justice itself is in the dock. Can you give us a little bit of an idea of why they would be releasing him after 8 years?
Yes, so the sentence he received was an IPP, which is imprisonment for public protection, with a minimum period of 8 years in prison. Now, what that meant was that he's then subject to licence with strict conditions for 10 years after his release.
So the IPP, this is a law that has now been repealed.
Yes.
So does that mean that when they gave him that sentence, they understood he was in fact going to be staying in longer?
No, no. So the sentence was applied as it was at the time. You're quite right, it was repealed in 2012. And the reason it was appealed, in fact, is because it was described as a stain on the justice system. But because people who committed more minor offences were caught up under this legislation and, in fact, were being detained for longer than they really should have been.
Yeah, but it was there, wasn't it? Some people are now arguing for precisely this reason.
Yes.
That actually somebody who has committed offences of this scale shouldn't be being released after 8 years.
Well, I think with this, I mean, in terms of the sentence itself, obviously the judge can only sentence on the basis of what somebody's actually been convicted for. So he was convicted of 19 offences, which obviously sounds a lot, it is a lot. But out of those, one of the offences was an offence of rape. The others were offences of sexual assault. In fact, 5 of them were sexual assault. The others were a kind of drugging, putting it in general terms. So that meant that the judge could only sentence on the basis of the convictions brought in by the jury. So I think it is actually really important to say, well, actually, he's not been convicted of hundreds or 200s. The police can say what they like, but what they need to do is get the evidence in order for him to be prosecuted.
Kirsty, so the alleged sort of other assaults go into the hundreds, potentially more than that. As we were saying, there's disparity between what the police said and what people are speculating now. The reality is, as Kate was saying, there'll be victims waking up this morning, there'll be charities waking up this morning, hearing this news, or hearing about it late yesterday, and they will be absolutely outraged. Why? Talk us through what happened in the parole board, where they felt like it was the right time for John Worboys to be released.
Well, what happens at the parole board hearing is that the defendant, or the person, in fact, who's been convicted and is in prison, then has to persuade the parole board that he no longer presents a significant risk to the public. And the parole board will look at all sorts of expert evidence, which includes psychiatric evidence, psychological evidence. There will be the offenders' managers within the prison who will also give their evidence on how he's been behaving.
Can victims go to that and argue for them not to be released?
Yeah, well, certainly the victims' views can be taken into account. It's only one aspect of the evidence that's taken into account, but it's certainly their views should not be ignored. And one thing that seems from the newspaper reports to have happened here is that there doesn't seem to be any communication, in fact, with the victims, with these women, to say this man is going to be released shortly. And I think if that had happened, then things become a little bit easier. And also, I do think it does a bit of a disservice to publish that perhaps this man is responsible for hundreds of other offences if there's no evidence to prosecute him. If there is evidence to prosecute him, we'll prosecute him. If he's convicted, then he would be sentenced for further periods in prison.
There was a lot of controversy at the time, wasn't there, about the case, because he was arrested, and then released, which the police were criticised for doing. And while he was released, he then went on to offend again.
Yes.
Now, that in itself is concerning, because it looks like it's a pattern of behaviour. Even when you knew you were in danger of being caught, it didn't stop him. Would something like that be taken into account? Because that feels like, whatever he's presenting as his behaviour now, that is a really deep-rooted urge to do crimes like this.
Yeah, I mean, I think that is a good point. And in terms of the Metropolitan Police, not only were there complaints against them, but in fact there was a civil case brought against them for a completely botched investigation. Now, one thing that the parole board looks at is it will look at things like that. You know, how likely is he to repeat again? Will this work as a deterrent? Has he reformed? So since he's been in prison, he would have had to have done at least one course, and there was a sexual offenders programme in particular that he would have had to have completed successfully, although I have to say I think that was abolished this year on the basis it didn't work very well. But obviously the whole point of prison sentences is it's meant to include a rehabilitative section to it.